Now, here's more of the Brian Beatty Real Estate Show on the Big Talker, 1250 WTMA.
Welcome back, Charleston. Thanks again for tuning in to the Brian Beatty Real Estate Show here on the Big Talker, 1250 WTMA. We are in the studio taking your calls. My good friend John Quincy will take the call and patch you through to me. We'd love to hear your stories, questions, comments, concerns, experiences, all that fun stuff. The number here in the studio, 843-556-1250. 843-556-1250. Now, if you want to reach out to me personally, you want to talk about real estate, the idea of selling your home, buying a home, investing in real estate, want to learn more about getting into real estate as a career, my number is 843-345-1273. 843-345-1273. Or visit my website, listingsincharleston.com. Listingsincharleston.com. So we were just talking about some instances in which agents make some mistakes. And then we kind of got into some negligent behavior. And I really just want to kind of cover some various ways in which real estate agents are sued, how they kind of get themselves into trouble. And look, you can't prevent somebody from suing you. You can prevent yourself from all those issues by being really good at what you do, documenting your process, and following the rules, of course. I only had, in the 12 years that I've been doing this and the 1,000+ people I've represented, I have only had one ethics complaint made against me, and it was made by the opposing party. So it was the buyer that was represented by their agent with a different brokerage. I represented the seller. They weren't happy with a deal that my client was doing with a different buyer on a different property that I didn't represent and had nothing to do with, but felt the need to file ethics charges against me. And so, of course, I documented everything, sent it in. It got dropped. There was no case. I skate by those issues because I don't break the law. I don't, I'm not a sleazy businessman. And there are plenty of people out there that, frankly, are negligent in this business. They, at times, are fraudulent. They will say things that are simply lies to get you to maybe increase your offer or submit an offer in the first place. One of the most common ones is just failing to disclose a property defect. Real estate agents have a duty to disclose anything that materially affects the property. Something materially affects a property if it impacts the value or the desirability of that house, which are things like construction issues or improvements without permits or leaks or wood rot or things like that. And even if the agent didn't know about it, people still sue them because they are under the assumption that if the seller knew, then the real estate agent should have known. And obviously that's not always the case. There are plenty of times where sellers don't know what's going on with their own home. And there are plenty of instances where the sellers know and they choose to sweep that under the rug and never tell the real estate agent. But that's why when you buy a property, you're going to review something called a property condition disclosure statement. And it's a 5-page survey, essentially, that asks a bunch of questions about that house. And that is the seller's CYA document. That is the document that essentially is the get-out-of-jail-free card. If they know that something is going on with that house, they have to disclose it. They have to disclose that defect. And if when sellers are sitting down with their listing agents, they say, when it rains, the roof leaks. But every time it does, we just, we paint over the ceiling and you can't tell. Do we have to disclose that? And then that shady real estate agent is going to say, well, if they can't see it, no one's going to know about it. No, don't even, let's just not bring it to anybody's attention. Why cause problems? And all you're doing is just creating problems for yourself later on down the road when the buyer finds out, hey, this has been a recurring issue and there's a bunch of rotten wood up there. And now you're going to court. So you have to be careful about those things. It's always best to disclose. Another common instance in which agents find themselves in hot water is just breach of duty. It's probably the most common type out there. It's It's if an agent does not act in the best interest of their client, of course, they can be sued. So as an example, an agent receives 3 offers on a house. And I know for a fact this happens, and it's unfortunate, but it is what it is, I suppose. A listing agent gets 3 offers on a property. And they're talking to the seller, and they say, okay, which one would you like to accept? Here's what I think you should do, blah, blah, blah. And they say, okay, this is the one. I like this one out of the 3. I want you to go back to them, and I want you to, accept it. And so the seller, gives the listing agent the signed contract, and the listing agent is supposed to now deliver that to the buyer's agent. And between the time that the seller has signed the contract and the time that listing agent is supposed to give it to the other agent, another offer comes in. And this one's for, $500 more. It's, very, very, very similar, but slightly better. Just a hair better. Well, the seller would likely take that deal because it's a better deal for them. But the listing agent says, you know what? I mean, I was just at their house for 2 hours going through all these offers. Now I got to drive back there because they don't have a scanner, and I got to go through this whole process again, and then I got to call all the agents again. I'm not even gonna send this contract to the seller because you know what? They're happy. They've already signed this one. Let's just get it done. That is breach of duty. I mean, you have to present all offers to your sellers. Who cares how hard it is for you as a listing agent? You should be proud of the fact that now you've got 4 offers instead of 3, and one's better than the other. But agents are a little lazy. And sometimes they commit, these little crimes that seem innocent in their mind, when in reality they can have massive impact to the process. They can get sued and they can lose their license over it. And if you're interested, we're talking now about just some issues that real estate agents find themselves in and how you as a consumer can protect yourself by arming yourself with the proper information. And so we're going through some of these issues to ensure that as you're working with your real estate agent, you hold their feet to the fire. There's accountability associated with your agreement. And so if you have any questions or if you've had an experience that you'd like to share, the number here in the studio, 843-556-1250, 843-556-1250. And if you want to reach out to me personally, you want to talk to me about real estate, you're thinking of buying, selling, or investing, the number is 843-345-1273. That's my cell phone, 345-1273. Or go to listingsincharleston.com. That's listingsincharleston.com. So another thing that I see happen all the time, agents giving people legal advice. Real estate agents are not attorneys. Real estate agents, by and large, are not good at writing contracts. They're not even good at filling in the blank spaces. Then you get agents that are going to start creating, paragraphs of contractual language to attach to an offer, and a lot of it is just straight up garbage. And I'm trying not to throw the whole industry under the bus here, but you should see these contracts that we get. And if these agents honestly think I'm going to encourage my client to sign it, I have to ask the question of, hey, are you getting other agents to sign stuff like this? I had one agent who's been doing this for like 7 years send me a contract on a listing, and it was contingent upon the buyer selling their house first. And so all the contract said was it was contingent upon the sale of the buyer's home. And that's it. And that was the contingency. And if you're, sitting here listening to the show and you're thinking, well, what's wrong with that, Brian? It sounds perfectly reasonable to me. The problem is there is no time frame associated with that. There is no repercussion associated with that. What about, if a seller receives an offer that does not contain a home sale contingency while we're waiting for the buyer to try to sell their house? There are all these different angles that you need to discuss with the client. And this agent just said, hey, we'll buy it if their house sells. Nothing else. And so I asked her, are you getting people to sign stuff like this? And she's like, Brian, I didn't even know there was another way to do it. And she's done, I mean, I'm not kidding you, she's probably done over 100 deals in her career. I mean, we're not talking about an agent that just got licensed. And so that's the scary part. And so you have agents out there that are writing language into contracts that are just going to be an absolute nightmare if things go wrong. You know, we used to see all the time in our market this language that agents would insert into the contract, which would be, you know, contingent upon buyer's sole satisfaction with the results of the home inspection. Contingent upon the buyer's sole satisfaction with the results of the home inspection. Meaning, I'm not happy with this inspection. I'm out of here. You know, you have a house that's in basically perfect condition. And they say, yeah, you know, I saw the report. Don't get me wrong. Even on a new construction home, a home inspector will find something. There's always something that's going to be on that report, which means that there is always the ability for a buyer to get out of a deal for whatever reason whatsoever if they don't like the results of the home inspection. That's why we don't let language like that onto our contracts, or at least that's why I don't. There are way too many just way too many loopholes in the contract, kind of as it is, that are very focused on protecting the buyer, not so much the seller. One of which is the financing contingency. It says that, you know, contingent upon financing or you know, obtaining a mortgage, and that financing contingency expires at closing, meaning if at any point in time they can't get, you know, qualified for a loan, they don't get a mortgage, then there's this ambiguous language in the contract that says, well, hey, they didn't get a mortgage. They get their earnest money back. Sorry, seller. Too bad. There are ways of protecting yourself in that contract so that things like that don't happen. But again, agents out there giving legal advice, writing stuff on contracts that are poorly written, that don't actually accomplish what they're trying to accomplish, it's a problem. So make sure that when you're working with your real estate agent, that you have those kinds of conversations. I mean, if they're writing things into the contract, don't be afraid to ask or say, you know, hey, shouldn't we have the real estate attorney review this before we sign anything? It's not a bad idea, and it's you know, if somebody were to ask me that, I would say absolutely. I'm more than happy to do that, because I'm not an attorney again. But if you know, if you want to call into this program, you've had something like this happen in the past. You know, fraud is what we're going to talk about next, which is a big issue as well. The number here in the studio, 843-556-1250. This is the Brian Beatty Real Estate Show. And fraud is, you know, the difference between negligence and fraud is intent. With fraud, if a real estate agent acts, intentionally uses false information or makes false representations about a property, you know, in order to kind of gain an advantage during a real estate transaction, then yeah, that's fraud. And so one of the most common ones I see is overstating square footage. If you overstate the square footage by less than 20%, it's misrepresentation, it's negligence. But if you overstate the square footage by 20% or more, it's actually fraud. You can go to jail. And I see all the time. It's incredible how houses can grow the longer they stay on the MLS. You know, a home that was first entered into the MLS when it was built in, you know, 1988 was 1945 square feet. And then in 2003, it was 1998 square feet. And then in 2012, it was 2012 square feet. And then, you know, it goes back on the market and now it's 2225 square feet. And so here we go. It seems somewhat small in terms of how much that property's size has changed. You know, the difference between a 1950 square feet and a 2200 square foot home might not be all that noticeable to you as you're walking through it. But let's say that's in a really expensive area where a 2,000 square foot home is selling for, you know, $500,000. Well, if you're talking about a massive, you know, dollar per square foot, every square foot counts. if you're doing a $250 a square foot and your home has grown by 200 square feet, I mean, that stuff adds up quickly. But fraud in real estate it's intent based. They are doing something to gain an advantage during a real estate transaction by using false information or making false representations about the condition of a property. And so, again, if you have questions, if you have a story you'd like to share, feel free to call into the studio, 843-556-1250. We're going to take a break, and when we come back, I'm going to switch gears, and we're going to talk about selling a home this fall, what you should know and what you should consider. All that and more as the Brian Beatty Real Estate Show continues here on the Big Talker, 1250 WTMA. Stick around. We'll be right back.
More stimulating talk on real estate matters with Brian Beatty next on 1250 WTMA.